Okay, so it looks like we're good to go. So I would like to start first with a land acknowledgement. The OCC acknowledges the work that we do takes place on the traditional territory of the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, which is now home to many diverse nations, First Nations, Inuit, and Métis peoples. Our regional hubs and partners across Canada similarly gather on the traditional territory of many Indigenous nations who have cared for these lands since time immemorial. I got to tell you, today I'm so pleased to be part of this webinar. The OCC has been providing information to businesses about the AODA for many years, helping them understand the requirements, providing templates, and helping them break down barriers to participation for persons with disabilities. With greater inclusivity, it not only makes us stronger as a business community, but also strengthens our overall communities as well. That is why, we are very pleased and delighted to be part of this presentation on the AODA. I'm also very pleased to have Minister Cho here, the Minister of Seniors and Accessibility, and experts from Merritt and Berlis, Alex Kagan and Lorenzo Lisi, who will take us through the AODA presentation. Following their presentation, Lisa Kelledy, a program manager with the Discoverability program at the OCC, will provide the closing remarks. With that, Minister, welcome to the presentation. And I turn the floor over to you for your opening remarks for this webinar. Minister Cho.
Good morning. It's an honor and privilege to speak to you today. The Ontario Chamber of Commerce is one of Ontario's great treasures. You represent the entire province and continue to do great work representing your members each and every day. And today's event is a perfect example of that. Our government believes that each and every person in the province should have the ability to live the Ontario dream. And when it comes to accessibility, that means two key things for your members. The first one is that you can grow your business by being more accessible. There is a new market for each of your members to access. And the second one is that by being more accessible means you will have more access to an incredible pool of talent here in Ontario. We know that there is a skills shortage in Ontario right now. But let me tell you, there is a wealth of highly skilled talent. You are able to work, willing to work, have the ability to bring their skills to you. I want to thank Michelle Eaton for the invitation to open your webinar. And a special thank you to my longtime friend, Rocco Rossi, for having me here. Enjoy your webinar. Thank you.
Thank you very much, Minister, for those wise words. The skills shortage is certainly upon us. And, many surveys that we've conducted over the years at the OCC have indicated that top of mind for most businesses in Ontario, most of our members, is the need for talent. If you don't have talent, you can't grow. If you don't have talent, you can't prosper, and we can't create stronger communities. So, what a better place to look at for an additional pool of talent into that disability talent pool. So this is why the AODA is so important. It really helps businesses understand not only the requirements of the legislation, but also helps remove some of those barriers to inclusivity, which will allow us to tap into a much larger labor pool, when you think about it, 22% of the population self-identify as having some form of disability. It's imperative that we tap into the labor pool so that we can help our businesses grow and prosper. With that being said, I'd like to turn it over to Alex and Lorenzo to start the presentation on the AODA. Thank you, folks.
Great. Thank you very much, Louis. And thank you, Minister Cho, for your comments. We appreciate those. I'm joined today by my colleague, Alex Kagan, who really is the brains behind this organization. And thank him for putting together such a complete presentation. A couple of things. I couldn't agree more with what was said this morning in terms of a diverse workforce, in terms of accessibility, and specifically in terms of recruitment, and I would add retention. We are strongly of the view, and we are employer council, but we're strongly of the view that both with respect to inclusion for Ontarians with disabilities and diversity, that does create a stronger workplace, and it creates a talent pool during a period of a talent shortage, and also leads to retention. So let me give you a little bit of a sense of what we're going to do today. Alex, if you can switch to the next slide. This is our agenda. We're going to talk about the AODA, and you can see the topics that we're going to be going through there. Alex will take you through that in a very complete way. I will then speak on the Human Rights Code and talk about accommodation practices and some of the recent issues, particularly as it relates to vaccination policies and exemptions. And throughout, if you have any questions, please feel free to write those in the Q&A. Alex and I will collate those and try to get to them and group them together so we can answer any inquiries we have. So we're very pleased and honored to be here today. Take it away, Alex.
Thank you, Lorenzo. So to begin the presentation, we're going to focus on the AODA. That really is why we're here, and that's going to be the vast majority of the presentation. But if there's one thing we could emphasize again and again, it's that the AODA actually works hand in glove with the Human Rights Code, which is why after we look at some of those requirements and obligations under the AODA, Lorenzo is going to go into detail about accommodation needs for individuals with disabilities or otherwise, and how we approach that, especially in the current situation as we are hopefully moving away from the pandemic. So that's going to be towards the end of the presentation and really important. With respect to the origin of the AODA, it became law in 2005, and the policy objectives were to achieve accessibility by 2025. Now, of course, that 20-year horizon seemed like more than enough time, but it is quickly approaching, which is why we've seen some important milestones and deadlines happen as of January 1, 2021, with respect to web accessibility, which is an important topic and something we're going to address in detail during this presentation. The objective of the AODA was to remove barriers by standardizing processes and standards for accessibility. And as I said, it is intended to be complementary to the Human Rights Code, which focuses on accommodation to the point of undue hardship based on disabilities and other prohibited grounds of discrimination. But what makes the AODA unique is that it is not a complaint-based system. Instead, it is intended to be proactive in order to identify and mitigate any barriers that our employees have because of a disability, or our customers, or our clients. And that's actually quite interesting, because when you consider other employment-related legislation, such as the Employment Standards Act, the Human Rights Code, the Occupational Health and Safety Act, typically those are complaint-based systems in which an employer has obligations that they have to meet. But to the extent that there's an issue, those are issues that are raised by workers to say, you're not doing this properly. Whereas with the AODA, we actually have compliance reports and we have compliance obligations from the time we have our first employees. So that's what makes it very interesting. And I know that's also what makes some employers a bit anxious, because they know they have these obligations, but they're concerned they're not meeting them. That's why we're going to go through it in detail. And at the very least, we're going to recognize where we might have some gaps and develop a plan for addressing those gaps. So who does the AODA apply to? If you have one paid employee in Ontario and they're providing goods or services to the public or other organizations in Ontario, the AODA applies to you. That may come as a bit of a surprise, but it really shouldn't. Keep in mind, for example, who does the Employment Standards Act apply to? Anyone with one employee. Just because you have one employee doesn't mean you don't get to ignore the minimum wage laws. Just because you only have one employee doesn't mean you can ignore accessibility standards. Keep in mind it applies to public organizations, private organizations, and not-for-profits as well. Now, accessibility standards do vary based on size. The larger the organization, the more responsibilities you have. Smaller organizations have less, all the way up to the Ontario government and other government bodies which have significantly more responsibilities. Even if you have only one employee, you still have responsibilities, but they are not particularly burdensome. And what we hope is that in the course of this presentation, everyone will feel confident about the compliance obligations they have to meet. And we are also going to include at the tail end of this presentation a list of fantastic resources that are free that you could use to go online and confirm what your obligations are and give you the tools to resolve them, any gaps yourself. Now, keep in mind when we're talking about the size of an organization, we are only referring to paid employees, not volunteers, not independent contractors. As employment lawyers, we're always cautious about whenever we see someone say, oh, I don't have any employees, I only have independent contractors. That's a whole other presentation, but the point being, just because you label someone an independent contractor doesn't mean you are necessarily not obligated to satisfy your AOD standards. On the point of volunteers, this is actually very interesting because even though the way we count the size of our employees and we consider our obligations, that's based on paid employees. And yet, as we'll see, we actually have specific training obligations when it comes to volunteers. So that's really important to keep in mind. If we're, a not-for-profit or we're associated with a not-for-profit and maybe we only have 6 or 7 paid employees, we're a small organization, no doubt. But there's some very small charities that might have thousands of volunteers. And when those volunteers are engaging the public, they need to be properly trained in order to promote accessibility. So the good thing about the AODA is that it only has one regulation, and we're actually through this presentation going to provide a link to that regulation. And it actually makes the categories of different organizations pretty cut and dried. Under the AODA and the regulations, you are a small organization if you only have 1 to 49 employees in Ontario. You're considered a large organization if you have 50 or more employees in Ontario. And as you read through the regulation, and I do encourage you to do that, in some instances, you'll see obligated organizations, which might be a bit confusing. That's a statutorily defined term. It just means small and large organizations, as well as governments, et cetera. Anytime you see that an obligated organization has to do something, it means you have to do something. So long as you have 1 employee in Ontario, that triggers the obligations. Now, there is sometimes a little bit of confusion about what I would call the 20 employee rule, because as we know, or I guess I should remind everyone, when we had a compliance report recently due, and that was June 30 of this year, it only applied if you had 20 or more employees working in the province. And yet under the AODA, there's no such thing as a very small organization. Either you have 1 employee, you're a small organization. But when you actually read carefully through the regulations, it does exempt, in some instances, organizations that have less than 20 employees. So long story short, for the purposes of this presentation, occasionally we will refer to a very small organization. That's not an official statutory term, but that's just a way for us to have a clear conversation and say, look, if you only have 1 to 20 employees, there's certain things that don't apply to you. First and foremost, if you only have 1 to 20 employees, you are not responsible to file a compliance report. That applies to small organizations and large organizations with at least 20 employees. But I can't stress this enough. The compliance report is not actually exhaustive. We have to complete it. We have to comply with it. But just because you tick every box correctly and you're in compliance with the questions asked, it doesn't actually mean you're complying with everything under the AODA. And that's a bit confusing. So we're going to go through the compliance reports later on in this presentation, but that's something really important to remember, is that just because you don't have to file a compliance report doesn't mean you don't have to comply with the Act. And just because when you do file the compliance report and there's no apparent issues, it doesn't mean your job's actually done. So here's the regulation I was referring to, the Integrated Accessibility Standards. When we send out this presentation, or rather when the OCC sends out the presentation, this is actually a live link that can take you to it. one of the things I really like about the AODA is that it's actually clear and concise. The Employment Standards Act is a very technical statute with hundreds of provisions, many different regulations. The same can be said of the Occupational Health and Safety Act. Even the Human Rights Code doesn't have a statutory definition of discrimination, even though that's at the heart of the code. Instead, you have to look at case law to understand what is discrimination, what is not. And it's challenging for employers. The great thing about the integrated accessibility standards is that there's fantastic resources online and we're going to supply that. But frankly, even if you just read through the act, the parts are clearly labeled. It says what applies to a small organization, what obligations apply to a large organization. It's in very clear English. There's lots of statutory definitions, and you actually get a pretty good sense about what you need to do. So there's different parts. First, there's the general. That includes accessibility policies and training obligations. We'll talk about that in a few minutes. We also have information and communication standards. That includes web accessibility obligations. We know that's been causing a lot of concerns and questions. We're going to address that and hopefully put people at ease. Then we have employment standards. That's not to be confused with the Employment Standards Act. What that really means is the employment standards under the AODA. Then we have transportation standards, which really applies to public transportation. Part 4, for the purposes of our conversation today, really isn't relevant for small businesses tuning in. Then we have the design of public spaces. Again, if you are in the business of designing public spaces, or that's maybe part of a new project you're taking on, then that's something you certainly need to be aware of in addition to the building code. But for our purposes, for the day-to-day businesses that we deal with, the design of public spaces is really not an issue that comes up much. But if it does, obviously we work with our clients accordingly. Then we have customer service standards. This is a misnomer. When I think of the term customer service standards, what comes to mind is a hotel, maybe a restaurant, people who are dealing with customers coming in off the street on a day-to-day basis. Customer service standards really applies to every business because customer means any client. So I can tell you, we work in a law firm. We're not what you would consider to be in the customer service business, but we are. We absolutely are. And when a client comes into our firm and they're in need of counsel, we have a responsibility to treat them with dignity and respect and to ensure that we are able to communicate with them in a way that they can understand it. And we'll explain what that means, but it absolutely applies essentially to every business because every business has clients. That's what we're here to do, is to service our clients or our customers. Finally, we have compliance. There are very strict penalties for non-compliance. We know that scares people. We're going to talk about what those are and how to avoid them. And fortunately, it's on an escalating scale. So the worst penalties are for the people who are getting themselves into regulatory trouble again and again. And if you're having one issue, for the most part, it's not financially burdensome. Nevertheless, we want to get ahead of any kind of penalties. So let's talk about part 1. This includes the accessibility policies and the training obligations. For both large and small organizations, you are required to develop, implement, and maintain policies regarding how the organization is going to achieve accessibility as per AOD regulations. As I mentioned, there's great resources online that have template policies. We could obviously assist it if a business felt like they have a unique situation where they really want to address accessibility in a way that is custom. That's fine. Large organizations have to put those accessibilities in writing and make them publicly available. Whenever the AODA or the regs mention making something publicly available, the best way to do it is to have on your web page and an accessibility section. If it's intended for a public audience, obviously it would be on the public website. If you're talking about something that's really more intended towards just employees, maybe you would put it on just the intranet. But to the extent that you need to make something publicly known, putting it online is a fantastic way to achieve your compliance obligations quickly and easily. One small point. Throughout the regulations, there are many instances where large organizations are required to put their policies in writing, whereas small organizations, that's 1 to 50 or 49, I should say, they don't have that obligation. But if there's something we hope you could take away from this presentation is, yes, you need to understand your statutory minimums, but try to think 1 or 2 or 3 steps ahead. If there were a regulatory issue and you needed to demonstrate that you had a policy, but it was unwritten, how would you evidence that? I guess you would go back to your notes to show we had meetings, we had conversations about it. But the thing that employment lawyers are always stressing is, to the extent that you have a policy, put it in writing. If you had a conversation summarize the points of what were discussed. Putting something in writing, shouldn't be viewed as a burden. It actually is an investment of your time to avoid the burden of compliance obligations down the road and having to demonstrate them. So to the extent that even a small organization doesn't have to put something in writing, it's just a fantastic way to get ahead of any issues to make sure you document as well as possible. Then we have large organizations that are obligated to implement a multi-year plan, which outlines the strategy to prevent and remove barriers. Again, everything about the AODA is about being proactive. The idea of, if we're building, as for example, public transit in a city, the last thing you would do is build it without thinking about accessibility and wait for complaints to flow in. The second the first engineer puts their pen to paper, they should be thinking about accessibility. And the multi-year plan is a way to hold up a mirror to the organization and say, we recognize that we don't have total accessibility right now, but here is our plan to get there. Not required of small organizations, but again, thinking proactively about how you're going to resolve problems over the coming years is always, encouraged by the government and a great way to avoid problems before they happen. Then we have, for large and small organizations, they have to ensure that they have appropriate training with respect to accessibility standards, as well as compliance under the Human Rights Code. Again, the AODA and the Human Rights Code work hand in glove, so you really can't talk about one without the other. And frankly, where the AODA leaves is where the code starts in some ways. You try to reduce barriers in the workplace, but then someone approaches you and says, notwithstanding your efforts, I am having difficulty in my job because of my disability. What do we do now? And that's where Lorenzo is going to go into detail about accommodation strategies under the code. So the AODA must include several points. These are actually included in the regulations. Of course, they could be more thorough and they can also be tailored to your specific business. As I said, a law firm might deal with customers in a different way than a restaurant. And that's why the training, perhaps for someone who's working in customer service in a restaurant, needs to have even better training than just the statutory minimums. But at the very least, there needs to be training about how to interact and communicate with persons with various types of disabilities, how to interact with persons with disabilities who use an assistive device or a service animal, how to use equipment or devices available on the premises in order to assist in the provision of goods and services, and what to do if a person with a particular type of disability is having difficulty accessing the goods or services. At all times, it falls under the principles of dignity, inclusivity, and respect. And the good news is that in the 2021, because of the advent of technology, sometimes the solutions are actually quite simple. If we have, for example, a hard copy of a menu and someone who is visually impaired can't read it, well, can we put that menu online so that they can use their assistive devices to read it? It's a pretty simple solution, but just by using technology and making something digitally available, you're now putting someone in a position who uses an assistive device to interpret that document the way that they can instead of the way perhaps it was originally. Keep in mind that training must occur as soon as quote unquote practicable, which basically says that there's no specific deadline. It doesn't mean, when we hire someone new, the very first thing that they do is the AODA training. We know sometimes people are, jumping into a fire and they got to pull it out. There's work to do, but it does mean that as the weeks pass, there really should be a plan to say, what, we need to, we know things are busy, but we need to do our training. And also when the training, we actually have to provide training every time the policy changes. And that's important too. Again, this is just good hygiene where I think, frankly, we shouldn't just train somebody once and 8 years passes. We are constantly improving our policies. We are constantly revising them. It is a good idea on an annual basis to record who's been trained in what and to consider a refresher. It doesn't have to be an all-day course. We don't have to pay to go off-site. Sometimes it's just as simple as, reviewing a free resources online and confirming that you had, or in-person meetings with the trainer if the business can't afford that. Moving on to the employment standards, this is part 3 of the regulations. So the following applies to both small and large organizations. So even if you only have 1 employee, this still applies to you. Notifying employees and to the public about the availability of accommodation. This can be as simple in a job posting, essentially noting, by the way, we are committed to inclusivity and diversity, And we are, to the extent that you need any accommodation, please let us know and we will make our best efforts to provide that accommodation. I think as a good rule of thumb, it's important to have one person in the organization who really takes ownership of it. If no one owns it, then it doesn't get done. So I would literally have someone's email address to say, if you have questions or concerns about accessibility as you're applying to AODA and Berlis, please contact Alex Kagan and he'll reach out to you as soon as possible. Another thing, again, reiterating when you're actually making an employment offer, making it clear that the person has access to those policies that should already be in place. And then upon request, arrange for accessible formats to the extent that it's necessary. And this is an important point that sometimes employers aren't aware of, which is they need to have individualized workplace emergency response information provided to employees with disabilities. Consider the standard fire drill. People move to the stairwell, they go down the stairs because we can't use the elevator. Well, if someone can't use the stairs, what's the plan? And there should be a plan and they should be aware of it. And in some cases, it might be as simple as we'll wait to the person who can't use the stairs, if that's the only exit, there's a designated zone. There's someone from the office who will engage EMS, direct them to that area. But it doesn't have to be a 30-page document. It frankly probably doesn't even need to be a 3-page document in many instances. It's just being thoughtful about the people who can't necessarily follow the standard protocol and how we make the workplace safe for them. Now, large organizations have a separate obligation, and that's to provide an individual accommodation plan for employees with disabilities. And there are specific particulars of what those individual accommodation plans require that are outlined in the regulations. Long story short, this is actually really valuable, and it's something we would recommend even for smaller organizations, because the last thing you want is to have a conversation about accommodation obligations, about the need for the employee to actually provide medical confirmation, for example. It's a discussion, but then no one writes down what the conclusion was, and there's no follow-up. And suddenly a year goes by, and the employer thought, well, we've done everything right. We had a So just following up on that point, even if you are a small employer, it could be really valuable to the extent that you are. Before we move on, if we can create an individualized accommodation plan, even though it's not statutorily obligated, we do know that under the Human Rights Code, we have to accommodate to the point of undue hardship. And part of that process is actually documenting it so that we can demonstrate that we have come to this challenge with good faith and we're deliberate, and we actually explored all the options and created a real plan to let someone thrive in the workplace, notwithstanding a disability. So here's a subject matter that got a lot of attention recently, and these are the compliance reports. Large organizations have to file these reports every 3 years. So do small organizations. But as we remember, our quote unquote very small organizations, they're exempt. But just because they don't have to file the compliance report doesn't mean they don't have compliance obligations. I'm going to say that probably for the 5th or 6th time because it's so incredibly critical. You don't want to be caught offside and say, well, I thought I didn't have to. I didn't have to file the report. The report is secondary. It's the things you do on a day-to-day basis. That's what's critical. Now, the reports originally were due. Oh, I'm sorry. The first report was due December 31st, 2014, and they've been due every 3 years since. Due to the pandemic, the deadline of December 31st, 2020, that was pushed to June 30th. That has come and gone. So if anyone is listening to this and they haven't filed their compliance report, it's absolutely critical that you remedy that without delay. Keep in mind the next compliance report for small and large organizations is December 31st, 2023. That gives us lots of time to comply, but that doesn't mean the compliance standard starts on that date. It just means that's when we take a snapshot of the business and report that we are in compliance. So to the extent that we have any gaps, we should address those without delay. Now, in the accessibility compliance report, it's a relatively simple document to complete. The only thing that makes it a little bit tricky is that it's a little bit of a plug and play, where as you add information, it expands. and that makes it slightly more difficult to read it in one piece and know how you fill it out. There's a simple workaround. Frankly, I think you just sort of almost complete it as sort of Acme Co, and you sort of think about what the issues are, and then you slowly look through what the questions are, and then you print it out, and that way you can see from top to bottom what you're responsible for, which maybe you wouldn't see when you just input the initial information. But you need the basics: full legal business name, business number, total number of employees, because of course there's a step change between 20 versus 21, and then above 50 as well. And then the name and contact information for a senior officer. That's actually important, because this is the person who is attesting to the fact that the information is true. This is not something that should be handed to the intern, compliance, just get it done. This really should be owned by someone who has authority to say, we're not doing right, we have to improve, here's the plan. And it really should be someone of stature within the organization. This is actually an interesting point. When you look at the compliance report for the small organizations, only 20 plus need to do it. The only thing it asks you to report on are the customer service standards, okay? That's how we deal with members of the public, whether they're clients or customers. But we still have training obligations, we still have policy obligations, we still have accommodation obligations. Those aren't asked for in the compliance report, but they're still necessary. The compliance report for employees with 50 or more, that's a little bit more complete. That covers the entire integrated regulation. Nevertheless, I wouldn't necessarily rely on this and just say, oh, well, if I click yes, everything, I'm fine. You still really need to think about the regulations and all the support we have to explain what they are, and really feel confident that even if there wasn't a compliance report, we are completing everything up to code. So there's only 5 questions for small organizations. Does your organization permit people with disabilities to use a guide dog? Do we permit people to use a support person if necessary? The answer is likely yes. We have a policy that specifically says, of course, we welcome individuals who need a guide dog or support person. Are we providing training to our volunteers, our contractors, or anyone else? Again, let's just sort of emphasize this point. The size of your organization is only based on paid employees. But if you're engaging independent contractors or volunteers to represent your business with the public, those individuals need to understand how to work with people with disabilities. That training is mandatory. There also needs to be a mechanism to provide feedback if we're falling short. That's pretty simple. Could be, accessibility at acmeco.com. It's reviewed. We have a plan for reviewing it on a timely basis. And is the organization otherwise complying with all other accessibility requirements with respect to customer service, which really should be thought of as client service. Now, unlike large organizations, small organizations are often exempt from various documentation obligations. But as we've said, documenting any training, policies, accessibility notices is highly recommended. There's 20 questions under the accessibility compliance report for larger organizations. We're not going to go through all 20, but these are the critical ones that I would be thinking to myself if I run a business. To the extent that we can't answer yes right now, it means we should really think about our compliance gap. Do we have accessibility policies and a statement of commitment with respect to honoring the AODA and its principles? Do we have a multi-year accessibility plan? Are we providing training about the AODA and the Ontario Human Rights Codes? Are we satisfying our customer service standards? Those are the ones we just talked about a slide before. Do we have a workplace emergency response information for all our employees with disabilities? And are we complying with information and communication standards? That includes web accessibility, which we're going to talk about next. Oh, sorry. One other point. This is a question this is an issue that created a lot of questions. Question 13 to 20 of the most recent compliance report, which won't necessarily be the same in 3 years, it focused a lot on the physical premises and the design of public spaces. Long story short, if you are a tenant and you are leasing premises, those accessibility obligations, those fall on the landlord. However, there are some instances where a tenant might still essentially take ownership of a certain space. For example, you're renting a space and then there's the reception desk, in which case you need to think about how to make that accessible. But to the extent that you don't have plans to retrofit a building, you are not under an obligation when you're filing a compliance report to explain how you are going to build a ramp if there should be a ramp and there's not. essentially you're grandfathered in to the extent that maybe something isn't up to code right now, but the next time there's a renovation, there must be. But to be clear, the building code always applies. So just because the AODA might say you don't need to spend $50,000 making the workplace accessible by building ramps, et cetera, if you're offside of the building code, you're offside of the building code. And unfortunately, that's just part of being an employer in Ontario, is that you have multiple statutes that are stacked on top of each other at any given time. Okay, let's talk about web accessibility. This got a lot of attention because we actually moved from level A to level AA, but only for large employers. But the reality is that large employers already had obligations with respect to web accessibility since Jan 1, 2014. So maybe this is coming as a surprise, but it really shouldn't. We should have already known that we had to be conscious of web accessibility. This is not a recent development. Now, the reason it got attention, though, is that as of January 1, 2021, large organizations sort of had to elevate their standards. And it was from the level A under WCAG, it's not a great acronym, I know, to level AA, which is considerably more challenging. The good news is that there's two costly criteria under level AA, which weren't applicable. They were specifically carved out of the statute. One is captions, and the other is audio descriptions. Another point is that technically web accessibility does not apply to intranets, but why only meet the statutory minimum? If you're already going through the process of making your website presence accessible to your clients and to the public, why in the world would you not go through that process with respect to your employees? It's highly recommended that you do both. Now, a question we often get is that, I don't control my own website. So I want to change it and I want to be accessible, but I can't. Well, the statute actually recognizes that you're not obligated to be web accessible if it's not practicable. You're also not obligated to change the website if you specifically don't have control over your website, or for example, you don't have a contractual relationship that gives you the right to modify the product. The challenge is there's really no statutory definition for practicable, and there's no case law, and there's been very little enforcement on this subject, especially because it's a very recent standard, at least with respect to the stringent standard. So the question is, what is practicable and what isn't? And I think something that's actually come up a fair bit is that, we hear from many of our clients, well, look, I don't control our website. That comes out of California. And we told them about the AODA and they said, yeah, they'll get around to it, but what can I tell you? They're not willing to do it. To me, that's very challenging. I think that's a bit of a weak argument to the extent that you have a regulatory enforcement issue when you have someone in Ontario who's trying to use your website, but can't. It's one thing if you're bought a product, for example, and you have a 3-year term on it. And until that 3-year term is over, you really just can't change the way your website looks. That's a decent argument. But just to say, well, I called the guy in California and, Ontario is a bit of a small market and they're just not willing to put the time and the money. The challenge is if I was, a compliance officer, I think my response would be, look, when you do business in Canada, you have to respect the criminal code. And it doesn't matter whether or not someone in California thinks it's challenging. You do business here, you have to respect the criminal code, the Human Rights Code, the Employment Standards Act, the Occupational Health and Safety Act, and the AODA. And maybe that is a burden. And that's, we're sorry about that. But you can't say you can't control something just because you don't have enough, influence within your own company to meet those compliance obligations. So I think to the extent that you perhaps maybe, I know there's some people on this call who might be in a franchisor-franchisee relationship and they say, look, I'm just one franchisee, what can I do? Document your attempts to motivate the franchisor or just the central headquarters that this is not optional, that the AOD obligations, including those web accessibility, they're already in our rear view. They came in force January 1st, and every day that passes that we're not being proactive to close the gaps, that poses a liability. So let's talk quickly about penalties for non-compliance before we move on to the Human Rights Code accommodation. The Accessibility Directorate of Ontario is responsible for the enforcement, and they have significant powers to issue inspections, compliance orders, and administrative penalties. The penalties range from minor, moderate, and major based on essentially the impact. If something's just an administrative requirement that you didn't achieve, that is going to be considered a minor offense versus something that produces true health and safety risk. We also know that if you have, for example, just one instance of contravention, that is going to be treated very differently than having 6 or more previous contraventions within the 2 reporting cycles, which are based on those compliance reports being due. So here's just a quick summary of really what the consequences are for non-compliance. You know, if you're an individual or an unincorporated organization, you could see that if it's your first time offense, you know, and it's a minor incident, it's not particularly cumbersome. But as you kind of move up the chain and the regulatory contraventions are more serious, or it's happening again and again, suddenly it does become quite costly and quite serious. So, you know, I think the takeaway is that if you're an organization, what should you be doing right now to make sure you comply with the AODA and the integrated regulations? You know, first and foremost, do we have policies? Have we done the training? When's the last time we've done the training? Do we have the accommodation plans? That's not enough, but those are the big ticket items you really need to be thinking about. If you're a large organization, you should be thinking about your compliance under the WCAG standards level AA. And frankly, even if you're a small organization, I think you should be thinking about web accessibility. There's currently no statutory minimum, but the way we started this conversation is trying to, you know, bring in talent in from unconventional places. And to the extent that we're not making our intranets or our internets websites accessible, we are denying ourselves a fantastic talent. So there's really no time to waste. Finally, here's a couple of resources. You're going to be sent this presentation, but these are just fantastic resources about how the AODA works, great government resources. These are 2 examples of training where you could literally provide this to your employees or volunteers, et cetera, and it satisfies the act. And then we have fantastic resources for web accessibility, which not only explains exactly what the standard is, but also we have different tools here which can show you where your gaps are. And it will literally take your website, but show you how this would be inaccessible to an employee or a customer or client. So having said that, I'm going to turn over to Lorenzo Lisi to explain how accommodation works in the modern workplace.
Great. Thank you very much, Alex. Excellent presentation. There's a lot of information there, but let's get into the human rights and accommodation in the workplace. Next slide, Alex. One of the things that we want to talk about is just this connection, and also wanted to a brief description about what's going on with accommodation in the workplace during COVID-19. There has been a lot of questions that we get from employers. We could spend a whole half day on this, but I'm going to go over this in a general way so you get a sense of it. So we all know what the duty to accommodate is by now as an employer, and it is in services, employment, or accommodation. You cannot discriminate on prohibited grounds of discrimination. And there they are right there. And these are very, very similar across provinces in Canada and in the federal legislation. So what that means is that you can't deny a service, you can't restrict accommodation, or you can't discriminate against in employment on these bases. And they're very broadly defined under the legislation. So for example, if you say, I don't like guys in gray jackets, I don't want to hire a gray jacket guy, that's not discrimination. It's not on a prohibited ground. But if the gray jacket has something to do with the fact that of my creed, of my status, of my expression, that may be a problem. So you really got to be careful about that. And you have to make sure that these things are recognized when you're looking at people in employment. Next slide, Alex. Now, the pandemic has created a whole bunch of issues with respect to creed, religion, family status, and disability. What we really saw, and we're going to talk about the mandatory vaccination policies specifically, but I also want to talk about the challenges that have been raised in family status and disability from the pandemic, and specifically because of the fact that people may be at home, they're raising kids, they've got elders in the house. These have all been very live issues for employers during the pandemic. None of you listening to this will find this as a surprise. You've been living it since March of 2020. But no matter what happens, you're still under an obligation to accommodate where it is triggered under the code. Next slide. So a lot of employers ask, look, what if we just get an agreement? you can't waive your human rights. It's just not permitted. You can come to a settlement in which the employee acknowledges that their human rights aren't an issue, or that they've settled any matters resulting from any alleged discrimination. But we have to remember that because we're looking at the connection between a ground of discrimination and the treatment, all right, if it's not connected to that, if there's not that causal connection, then it's not protected. And really important for you to understand, because this is really where the rubber hits the road for employers, is you can protect needs. Those are protected on those prohibited grounds, but a preference is not. A really good example is family status. Somebody says, I got to get home early from work because my daughter plays soccer. Well, that's a preference, not a need. But if the daughter if soccer is part of a program or a health program, or for example, a mental health program for a child with needs, that might be an accommodation that you have to look at in terms of adjusting the schedule. So it's a case by case. There's not any one rule. We get those questions all the time. Well, what do we do? What's the rule? The rule is that each case is specific, but we know where the goalposts are. But within those goalposts, we got to look at it independently. We've got to assess individual. Alex. So there are two components to the duty to accommodate: procedural and substantive. Okay. And the duty is to the point of undue hardship. The duty to accommodate is to the point of undue hardship, which is a very high duty. So procedural means that when you're assessing the requirement, you have to put the process in place to look for what jobs or how you can accommodate. So what are the jobs, or what are the modifications to the jobs? What's in the workplace? Is bundling appropriate? And then the substantive duty, which is implementing that accommodation. And to do that, you need information. So we don't hesitate in asking for information on restrictions. We'll talk about that in a bit. But undue hardship means it's a defense, but there's a very, very high threshold. Safety is important. So if the obligation to accommodate, for example, sending an employee who may have a sensitivity who asks for accommodation into a workplace where that sensitivity may be exacerbated, like a woman, for example, who is pregnant, you may say, we can't send you into a certain job because that might exacerbate or put you at risk. But the cost is generally considered to be very, very high threshold to reach. Employers are frustrated by that. We get your pain, but that is the issue. Cost is very, very hard to demonstrate undue hardship. So is morale. You can't say, well, everybody's going to be upset if we've got to bump somebody or do this. The other issue is collective agreement requirements. They can be considered if an accommodation issue may bump seniority rights under a collective agreement. Again, a case-by-case basis. Alex. So how do we deal with vaccination policies? Well, I can tell you, we've been doing this for a while now. And what we need to tell employers is, and what you need to understand is that you're required to accommodate, and the methods of or the issues of accommodation for vaccinations and mandatory vaccinations are basically religious and medical. All right, those are the two common. And the Human Rights Tribunal, or the Commission, sorry, has come out and actually given some guidance to say personal preferences, personal choice is not protected, but disability and creed and religion are. Alex? So we haven't seen very many medical exemptions. There have been some allergy exemptions that we've looked at, but there haven't been a lot of them. We've been now for mandatory for vaccination policies looking at these for about 3 or 4 months. And one of the things you have to look at it, if it's medical, all right, we need to know, how does it prevent, is there a medical reason which prevents the vaccination? How long is it expected to last? And then you've got to trigger that procedural and substantive obligation. And that is, for example, can you do it remotely? Can you do it on site but alone so that there's protection to the employee and others? And can you use testing to somehow implement that accommodation? Again, if you throw the cost on the employee who needs to be accommodated, not an employee who doesn't need to be accommodated, who hasn't established a medical or religious grounds, that might be discriminatory. So we're very, very careful about that. That's where you need to get the advice. Alex? And one of the issues that we find is that when it comes to creed religion, this has been the majority of them that we've been getting. And you can ask for confirmation from a religious leader. You can look in in good faith and make inquiries about the sincerity of the belief. But what we're almost exclusively seeing is cut and paste requests that come from other sources, some from the United States, saying it's a violation of the Constitution, of the Bill of Rights, those are personal choice issues. All right, those don't go to an accommodation of creed or religion. We have gotten those examples where we get it from the head of a religious institution that says it is our faith. Some religious institutions leave that from a church-to-church basis rather than a general inquiry from the top down. The Catholic Church, for example, has made a statement from the Pope saying vaccinations are encouraged. So when you get an individual saying the Catholic faith says that, we can say, look, the Vatican has said that we're really encouraging this. But it can't just go to personal choice, which is my religion gives me the personal choice to do this. That's, in my view, not going to be acceptable. Alex? So I want to touch on family status as well, because what we found during the pandemic is that we had a lot of issues with employees, particularly early on, who were saying, look, I've got elder care. I've got kids at home who can't get to daycare, who can't get to school because they've closed down. A lot of that has changed because of the fact that schools have been open, because of the fact that we now have a better sense of elder care. A lot of the facilities that can deal with our aging population are now kind of up and running again. So we have to make that inquiry, and we're allowed to make that inquiry into what's available. Schools are open now. Why do you need this requirement? Some people may say, I have chosen to keep my child home from school because of a concern over COVID. That's now straddling the line, okay? So personal choice versus true concern is the deal. Go ahead, Alex. What we got to do is we got to be flexible. And no good deed goes unpunished sometimes. If you've shown an example in the past of accommodating needs, then that may be an example or evidence of the fact that you can do it again. But we can look at other things and how it's done, working remotely, providing modified schedules, or accessing available daycare for employees. All of those things, including putting them on IDL, which still exists until the new year. But we still have the risk that if you unilaterally put somebody on layoff or on leave, that may constitute a constructive dismissal. Alex? So when you're looking at, and you should have these policies in place already, the work at home policy. If you're going to have a work at home policy, or if you do already, make sure that you've set out the parameters. Where are you working? What are the security provisions on your computer? They've all got to be, make sure that these, that confidentiality, IT are all in place, and confidentiality. Define the workspace. Make sure that you've indicated to the employee that if you slip and fall taking the garbage out because you're working at home, that's not the workplace. There is a space that is defined where you do your work. All right. And you know, you got to tell them that in your policy, you've got to be available during this period of time. If you, like you were at work, you're just working at home. So defining a policy is very, very important. You need that to go forward. Alex? So process is very important. We got to take all requests seriously. All right. And you need to request the evidence. You can't, as an employer, decide if an accommodation is appropriate without knowing information. That doesn't mean that we ask what the prognosis is. We're not allowed to do that. But we can say, what are the parameters of the accommodation you required? If it's medical, what are the restrictions? How can we accommodate you? We need your doctor to tell us that. If it's family status, what have you done? What can we do? What are the available resources? Look at temporary arrangements, all right? Look at things that, and make sure that those requests are not unduly scrutinized or put open in the public. And most importantly, and I say this all the time, whether you go to Staples and get a binder with 100 tabs, or you do it virtually on your computer, document every step of the process, tab by tab by tab. That documentation will save you money when you got to come to guys like me if there's been an alleged violation of the code. Alex? And so that's kind of where we're at in terms of an overall view of, and I know that was very quickly done, but it gives you a sense of the connection now. And we really wanted to make that kind of a part of this presentation on the AODA. And here's some topics in the future. That's what I got to say. We're going to address some questions, and that might assist. Alex?
Sounds good. Thank you, Lorenzo. Why don't we take a look at some of the questions?
Sure.
I see one that's interesting, in which it sounds like someone was giving advice, or given advice, or I should say direction, about providing alternatives to certain texts that are signs or equipment. And the question is this specifically referred to in the regulations? Frankly, if someone's giving you advice about what you need to do and it just doesn't sound like it's practical, cost effective, you're kind of wondering, like, what exactly is the obligation? You have every right to push back and just say, okay, where does it say that in the regs? Because I want to make sure I'm interpreting it properly. And maybe their answer is, well, it's actually not specifically in the regulations, but you have a general duty to make something accessible, in which case you can show business judgment and do that, but it doesn't mean you have to follow someone else's specific instructions. I'm not specifically aware of any specific statutory and express obligation with respect to signs, but there is a general duty to make the workplace accessible. So I think on that point, I would probably just gently push back and ask why this particular consultant felt like this was such an important obligation. We also have a question about an AODA resource and whether or not that covers the training portion for their employees. They refer to the AODA.ca. That's actually not one that I'm particularly familiar with, but there is something I'd note that under the AODA, not only do you have to be trained in accessibility standards and obligations under the AODA, it also has to cover the Human Rights Code. So a couple of the resources we provided in our resource section does both. That's really important. You're going to have our presentation at, let's see, slide 8. It literally breaks down the statutory minimums of what it needs to comply. So if you go on this AODA website and it checks each of those boxes, fantastic. I'm just not familiar with this particular one offhand.
And it's important, though, to remember the connection to the Human Rights Code. And it's also important, I'm just going to echo what Alex said, about the fact that there's nothing wrong with asking questions. Employers sometimes get beaten down because we're so afraid of making a mistake. And I consider myself an employer as well, that we don't ask the questions. Appropriate questions where you're narrowing and you're trying to understand your obligations are perfectly reasonable.
Absolutely. We also have a question about a delay in providing accommodation, how that impacted performance, and to the extent, how does that impact our role as an employer? And what I would say is, if someone has asked for accommodation and you've made good faith efforts to provide it, but life happens and maybe we've been slow to provide what they wanted, and their poor performance is potentially connected to that lack of accessibility, I think you really would be looking potentially at a discrimination issue to the extent you engage in any kind of discipline or demotion or termination, because, as Lorenzo pointed out, as long as there's a connection between a prohibited ground of discrimination that includes a disability or even the appearance and assumption of a disability and some kind of adverse treatment, that's discrimination. It only has to be a factor. It doesn't have to be the majority factor. There's no such thing as just a little bit of discrimination we're allowed to do.
That's right.
It always has to be a very clean demotion or termination where we can absolutely explain that a disability had nothing to do with it. So if we've been delayed in providing accessibility, I think that's incredibly muddy, and I would be concerned about taking any kind of adverse steps against that individual until they're provided proper accommodation.
So I think that's going to be our presentation. I know that there's a little bit of a wrap up, and hopefully we got to a number of the questions that you asked. On behalf of Alex and I, we would really like to thank you for your attendance and to thank the organization for allowing us to do this today and inviting us. It really is an honor, and we appreciate that kind of cooperation and connection. So thank you very much, Alex. Thank you for your assistance on this, and we can proceed to wrap this up on a timely basis.
Thank you. And we're going to turn it over to Lisa Kelly now for our closing remarks.
Thank you very much. Thank you both for joining us. I've been watching Lorenzo and Alex for a couple of years now on their webinars. I encourage you to follow it. They always have great information that's available for us around information in this space. I'd also like to thank the Honorable Raymond Cho for his introductory remarks. And I'd like to encourage any of you, if you're employers and you're interested in hiring a great talent pool, connect with me, Lisa Kelly, at occ.ca. And we would love to have you advertise your jobs and your positions for free on the Discover Ability Network. So with that comes offers of free training on subjects related to the AODA, but also about inclusion and recruiting accessibly. So all that is part of the offering when you are looking to build an inclusive organization. So thank you everyone again, Lorenzo, Alex, Louis, for the introductory remarks, and have a great day. Reach out if you have questions, and we'll be following up by sharing this deck. Thank you very much.
Thank you very much.
Thank you.